Complexification of disputes gives rise to the very real possibility of cases that are so complex or voluminous that they strain the ability of any single human adjudicator to process. In one construction arbitration, for instance, the tribunal reportedly received written submissions extending to 10,000 pages. Applying an estimate of 6 minutes to read and digest each page, it would take an arbitrator 1,000 hours, or about 6 working months, to read the submissions, to say nothing of the time it would take her to evaluate them in the light of the rest of the material. But even more routine cases may prove significantly more demanding to try using conventional methods, thus increasing the cost of litigation and compromising the expeditious disposal of cases. That is aside from the personal toll that working on such cases takes on lawyers and adjudicators. As science and technology continue their inexorable advance, these challenges will only grow. We cannot rely solely on traditional case management tools to deal with the problem of complexification. Instead, judiciaries will have to consider new and potentially radical ways to contain and downsize disputes or face a real crisis of capacity. And a third set of challenges come from the fact that legal issues increasingly disregard jurisdictional boundaries. This is because we are becoming more economically interconnected than ever before. Despite the well-publicized phenomenon of countries around the world shutting their borders and turning inwards at the start of the pandemic in early 2020, by the end of that year, transnational trade had recovered to pre-pandemic levels and has continued to grow since then. The volume of international commercial disputes that have connections with multiple jurisdictions will therefore keep rising. But international commercial dispute resolution is by its nature decentralized. There is no single predetermined control center for each dispute. Instead, each court has the prerogative to rule on jurisdictional disputes in the proceedings brought before it, including questions of whether the dispute is better brought before another court or arbitral tribunal, or has already been decided in another forum. In addition, we are sure to encounter new legal issues in areas ranging from cryptocurrency to environmental, social, and governance regulation and litigation, all of which rarely heed jurisdictional boundaries. The case for convergence or harmonization in many of these areas is obvious. If different jurisdictions applied their own idiosyncratic standards in deciding challenges against arbitral awards or the legal status of new types of assets, for instance, this would greatly increase the cost of compliance and transnational dispute settlement, and therefore stymie cross-border trade. This is why in areas like arbitration and mediation, the international community of states has come together to ratify treaties or to develop model laws. But even then, different courts do not always apply these instruments in a uniform way. The short point is that judges will increasingly need to be sensitive to developments in the laws of other jurisdictions in order to properly decide disputes. And beyond this, they will also increasingly need to actively cooperate with foreign counterparts in disputes that need effective concurrent cross-border management, such as the growing field of complex cross-border insolvencies. But courts have traditionally had neither the inclination nor the avenues to communicate and collaborate across jurisdictions. This is something that I suggest we all will need to work on, and I will come back to this point a little later. I turn to the next 3 sets of challenges which will directly affect the legitimacy of the courts. These two stem ultimately from global challenges such as rising wealth inequality, the risk of stagflation, and political instability, which we can expect to lead to a steady growth in disaffection and polarization in our societies. A recent report by Oxfam noted that the richest 1% captured nearly 2/3 of all the new wealth generated since the start of the pandemic. Some commentators argue that this extreme disparity in wealth is being created not through innovation or production, but rather through the exploitation of workers and consumers. Whether or not the charge of capitalist excess is true, what should most immediately concern us as judges is the reality that if the unequal accumulation of wealth continues to sharpen, we can expect grave challenges in securing access to justice for those left behind, who will feel increasingly marginalized and disillusioned with the justice system. Sharp economic polarization in societies inevitably contributes to the polarization of public discourse, and this too is accompanied by a phenomenon which might be called truth decay. Together, they sow the seeds of a series of challenges that threaten to seriously undermine the legitimacy of justice systems around the world, and it is to these I now turn. I begin with the challenges surrounding access to justice, which is being impeded not only by growing inequality, but also by the increasing complexity and cost of dispute settlement and pressures on the resourcing of justice systems and of legal aid. One manifestation of this trend is the steady increase in the number of self-represented litigants who navigate our justice systems. But this belies a much larger phenomenon of people with legal needs that never see the light of day. A study by the World Justice Project suggests that there are 1.4 billion people globally who are unable to obtain justice for civil legal problems such as property, matrimonial, or employment disputes. I have suggested elsewhere that the difficulties faced by potential litigants seeking to access justice consist of three facets: a physical gap, which comes from distance or other physical difficulties in accessing the courts; a resource gap, which comes from the financial and other costs of navigating a justice system; and a literacy gap, which comes from a lack of appreciation that certain problems are legal problems that come with legal solutions. Together, they constitute a justice gap, and its existence is a pressing concern because nothing is more corrosive to public trust in our justice systems than the perception that those systems are the preserve of a privileged few and priced out of the reach of ordinary people. A large part of the literacy gap comes from not knowing how to access the courts. A significant contributor to this is the folklore that often surrounds the law and the public consciousness, and which gives entirely incorrect impressions of how it operates. And it is becoming harder than ever to correct such misconceptions because of the next set of challenges, truth decay. This refers to the proliferation of disinformation and the devaluation of truth in our societies, which attacks the justice system in at least two specific ways. First, truth is the foundation upon which courts do their work. As Justice Stephen Gagler of the High Court of Australia has observed, the rule of law depends on our courts making factual findings that are reliable because justice, according to law, requires applying the law to the true facts. And while there does not appear to have been empirical studies on this, a number of recent examples suggest that truth decay is spreading into court proceedings. In Singapore, our courts have seen a rise in partisan and unreasoned expert opinions, especially, for instance, in psychiatric evidence adduced in criminal cases. And truth decay can also be seen in the conduct of some advocates who have in some cases attempted to conceal facts from the courts or to delay proceedings on spurious grounds. Second, it is essential that the findings of the court are generally accepted in the public sphere as generally reflecting the truth. If that is not the case, then our rulings become merely another voice in an endless clamor of opinions on the merits of disputes. This is exacerbated when baseless allegations are made against judges, suggesting that their rulings merely reflect their personal agendas. Perhaps the most notorious example of this is the Daily Mail headline in the United Kingdom, branding judges in the Miller case as enemies of the people, implying that they had sought to thwart the public's desire to leave the European Union. More recently, when the majority opinion of the US Supreme Court in the Dobbs case was leaked, a New York Times article purported to fact-check passages in the draft opinion that recounted the policy arguments made by the petitioners. The subtext seemed to be that the author of the draft opinion had distorted the truth in order to find for the petitioners and advance an agenda. As a result of its creep into our courtrooms, truth decay diminishes the standing of judgments and of courts, and this ultimately undermines the stabilizing work of the courts in upholding the rule of law and maintaining order in society. And this brings me to the final set of challenges, which is in many ways the culmination of all of the foregoing challenges. And this is the increasingly evident breakdown of trust in public institutions as a whole. The 2022 Edelman Trust Barometer found that distrust was now society's default emotion. In many democratic societies, less than half the people surveyed said they trusted institutions such as the government and the media. This may well be due to causes such as truth decay, but it is also likely to be due to the sense that public institutions are failing to deliver on their mission. We should not think that courts can stand apart from other institutions when it comes to this deficit of trust. The potential breakdown of trust in the courts is arguably the most critical of all the challenges that we face, because the legitimacy of the judiciary rests upon a broad public acceptance that we are reliable truth seekers and truth finders seeking to do justice according to the law. If this trust falls away, then the courts are left to operate solely by the force of state power, and the belief in and respect for the rule of law in our societies will collapse. I therefore suggest that judiciaries are facing the onset of a number of discrete challenges which strike at either or both of the core requirements for the discharge of our judicial duties, namely competence and legitimacy. These challenges come together to form a perfect long storm for the judiciary in the same way that Senior Minister Tharman has described those facing the world at large. They are a confluence of lasting threats, not random blips. And they give rise to a matter of serious public concern because the judiciary plays a crucial role in underwriting the legitimacy of our social, economic, and political institutions by ensuring that their activities abide by the law and that the law remains relevant under changing circumstances. It is therefore apt to characterize the challenges facing the judiciary as a perfect storm because they threaten the rule of law and ultimately of our institutions as a whole. The question might nonetheless be asked, should judiciaries be the ones to respond? After all, problems like truth decay and climate change are political problems, surely, in need of political solutions. To my mind, the answer is obvious, but the concern is worth addressing because it stems from a number of long-standing strictures that have traditionally defined and limited the judicial role. It has been said that judges traditionally held themselves aloof from the public. Thus, there are principles warning judges against commenting on government policy, defending their judgments publicly, or engaging with the media. And furthermore, the courts only act within the limit of their understanding of their proper constitutional role in line with the separation of powers. Even though the principles underlying these limitations, those of judicial independence and separation of powers, are well justified, they do not mean the judiciary should remain completely aloof. They do not go so far, and the strictest of these prohibitions have long fallen out of fashion. Thus, while judges generally continue to let their judgments speak for themselves, most judiciaries no longer see anything wrong with other facets of public engagement that spread awareness of judicial work. For instance, the Chief Justice of Canada holds an annual press conference discussing the work of the court, while members of the UK Supreme Court have given television interviews discussing their approach to work and their home life. These shifts in judicial attitudes reflect an evolution and refinement of our understanding of the judicial mission. And I suggest there are three aspects of this evolving vision of the judicial role that explains why we as judges must respond as best we can to the perfect long storm. First, and most importantly, beyond sitting as referees over disputes, our true mission is the fair and efficient administration of justice so as to uphold the rule of law. To look at this mission from a purely adjudicative or process-based view is to miss a much larger picture, which is that the administration of justice takes place within a system. And what an individual judge does when presiding over an individual case is only one part of how the system as a whole delivers justice. It is the effectiveness of the system as a whole that determines whether access to justice is available, whether judges are equipped with adequate expertise and tools, and whether public confidence in the judiciary is secured. We should, therefore, adopt a systemic perspective of the judicial role, in which the judiciary evolves from seeing itself as a collection of discrete adjudicators to becoming an institution that excels in the administration of justice. Second, by unpacking the perfect long storm into its constituent parts, we see that the challenges looming on the horizon are not just a morass of political entanglements for the other branches of government to resolve. Even though we in the judiciary cannot address many of their root causes, these challenges each have legal and operational dimensions that directly or indirectly impact the judiciary. As a result, these matters will enter our domain, and we're duty-bound to mount a response. And third, as the primary operators of the justice system, judges are best placed to act, albeit within the applicable constraints. From our own perspective as judges, we should also recognize the value in being active participants rather than mere passengers in the transformation of our justice systems. And because change is often resisted when it is imposed from the outside, by far the best way of achieving and maintaining the changes that need to be made to our justice system is by having judges actively participate in the process. So once we look at our judicial role from these perspectives, I suggest we will see that impartiality in the courtroom, whilst fundamental, is no longer synonymous with inaction in the face of the perfect long storm. On the contrary, we must act urgently and decisively to mount a sufficiently robust response to these challenges, while drawing up a refined set of boundaries for the judicial role. I therefore turn to the final question of how we should go about this Herculean task. First, I think it is crucial that we take a systematic approach. Many of these challenges appear so vast and foreboding, with root causes that are beyond our competence, that we risk losing steam or going off track if we respond in a piecemeal or reactionary way. We must develop a clear vision of the evolving role of the judiciary so that we refocus our efforts around what we can do to become institutions that excel in the administration of justice. When we look at it in this way, I suggest for a start, there are three key themes that should shape our vision of the judicial role. First, building a user-centric court system. Second, enhancing judicial competencies. And third, picking up a point that Justice Kaul made, promoting international judicial engagement. Let me elaborate on each of these in turn. The first theme concerns the importance of putting ourselves in the shoes of the public, who are our users and our constituents. Ultimately, the justice system does not exist to serve the convenience of judges and lawyers. Instead, we should adopt a user-centric approach to its design. Building a user-centric court system is an important way for us to secure public trust and legitimacy. There are two facets of the judicial role that I suggest should evolve in order to achieve this. First, courts should take seriously their assistive responsibility towards their users. I'll develop that in a minute. And second, we should regard public communications and outreach as one of our core functions. Let me take these in turn. First, we should recognize that even as courts must remain impartial, they also have an assistive responsibility towards court users, and in particular, litigants in person. Such self-represented litigants are a fact of life for judiciaries around the world today. And they face significant barriers that impede their ability to access justice because legal systems and court processes have traditionally been designed with judges and lawyers in mind rather than with lay users in mind. And that is simply not fit for purpose when the system is now accessed by so many litigants in person. To help bring down these barriers, the courts should draw a distinction between impermissible legal advice on the one hand and the provision of legal information and practical assistance on the other, and not shy away from the latter. One way the courts can achieve this at scale is by publishing guides and information packs with lay users in mind. This is an approach that our courts in Singapore have embraced. For instance, our state courts have published the guidebook for accused in person, which sets out in considerable detail what accused persons can expect at each stage of criminal proceedings and how they might prepare themselves. Our family justice courts have published the Family Orders Guide, for instance, which helps self-represented litigants cope with the alien task of drawing up draft orders of court. The Singapore courts maintain a single website which provides self-help procedural guides for civil, family, and criminal proceedings. We can also discharge our assistive responsibility to lay court users by making court processes easier to understand and navigate by doing away with legal jargon and simplifying our procedures. We should especially pay attention to the vast potential of technology to help discharge our assistive responsibility. Assistance which in the past had to be provided face-to-face by court staff and volunteers can be scaled up without limit and at relatively little cost if we find the right digital tools. Such tools can provide practical assistance to court users. For example, the divorce e-service created by our family justice courts guides self-represented family litigants through the entire process of preparing and filing divorce papers. Digital tools can even provide legal information previously available only by consulting a professional. We developed, together with the Academy of Law, the Motor Accidents Claims Online, an online tool that was launched to enable potential litigants to get a free preliminary assessment of the likely allocation of fault and award of damages. There is immense future and further potential for such digital tools to radically change the way justice can be accessed in the most commonly encountered kinds of disputes. Second, it is important for judiciaries to see public communications and outreach as an essential part of their role. Studies have shown that public knowledge about courts is closely linked to public trust in judicial institutions. The courts should therefore take up the task of spreading awareness of their work. I've already mentioned the annual press conferences held by the Chief Justice of Canada as a prime example of such proactive outreach, and there are other examples. The Singapore Supreme Court publishes case summaries of significant decisions on our website and on social media, and we compile annual reports setting out the judiciary's key work. We also collaborate with other stakeholders, such as law schools, to further our outreach efforts. But outreach does not only involve delivering our messages to the public. User centricity requires us to continuously be sensitive to what our users are saying, to be open to feedback from our users. We therefore conduct regular user surveys to understand the shortcomings of our court systems and processes so that these can be improved. These are just some of the ways in which we can narrow the justice gap, combat disinformation, and maintain public trust. I turn to my second theme, which is enhancing judicial competencies. I suggest we will have to raise the capabilities of our judiciaries if we are to keep up with the underlying drivers of complexification, to reduce barriers to accessing the courts, and to be prepared to face the new legal issues that are upon us. This is key to enable us to sustain our legitimacy because it will give the public confidence that we can discharge our responsibilities. I suggest this should translate into a renewed emphasis on two facets of the judicial role. First, we should invest significantly in continuing judicial education and training. And second, we should continuously pursue innovation in the justice system. Turning to the first point, judiciaries must take responsibility for the education, training, and development of those in their ranks. The historical view that judges required no training and somehow emerged fully formed at the moment of their appointment has long been discarded. Instead, we now accept that continual training and upskilling are a necessary part of a judicial career. This is not least because of the new challenges that are emerging in the perfect long storm, which places new demands on judges in terms of legal knowledge, scientific and technical understanding, effective case management, and even awareness of other legal systems. These programs will increasingly need to incorporate a significant element of interdisciplinarity. In Singapore, we established the Singapore Judicial College to deliver judge-led judicial education and training, and have been continuously upgrading its capabilities in order to equip our judges to meet these demands. And for these initiatives to work, judges themselves must fully embrace the need for lifelong learning. And besides our judges, we also need to develop our court administrators to excel, innovate, and lead, because they do much of the work of running our courts and interfacing with our court users. But enhancing judicial competencies on an individual level will not be enough. We need to raise the floor for legal practice as a whole and improve the functioning of the litigation process at a systemic level. This requires the judiciary to become innovators within the justice system so that we can employ best practices and explore new and promising solutions. In the Singapore courts, we've pursued a number of priorities in procedural reform, of which I will touch on just two. The first is to improve access to justice by streamlining procedures and deterring inefficient litigation practices. Following a multi-year study led by one of my colleagues, Justice Tay Yong Kwang, we rewrote our civil procedure rules. The new Rules of Court 2021 are governed by 5 overarching ideals, stated clearly at the beginning of the rules: fair access to justice, expeditious proceedings, cost-effective and proportionate processes, the efficient use of court resources, and fair and practical results suited to the needs of the parties. These ideals animate the management of cases by judges. And to achieve this, a high degree of flexibility is built into the rules with active judge-led case management at its core. Our second priority that I want to touch on is to develop and promote practices and tools that will help contain and downsize complex disputes. So, to help contain disputes, the new rules of court empower our courts to order the parties to attempt mediation. And to downsize exceptionally complex disputes, we introduced an optional protocol that the parties can agree to in the Technology, Infrastructure and Construction list of the International Commercial Court, which can streamline the adjudication of complex disputes comprising dozens or even hundreds of related claims. And to sustain these improvements, we will need to keep them constantly under review and keep our minds open to other new and promising practices, as the Chief Justice observed in his remarks. We will have to continuously consider what further skills or challenges we need to enable us to meet the emerging changes. And this is just part and parcel of taking charge of our own development and improvement so as to retain our competence to discharge our responsibilities. The third and final theme is promoting international judicial engagement. Gone are the days, I suggest, when judiciaries could operate in jurisdictional silos, unconcerned with legal systems and courts beyond their shores. Instead, it is both necessary and highly beneficial today for judiciaries to engage with their counterparts from other jurisdictions. And let me tell you that in just one day, I learned so much from the interactions that I had, both with the Supreme Court, the Delhi High Court, and indeed with the technology office of this court. I suggest that this new aspect of the judicial role again has two facets that cut across the goals of improving competence and securing legitimacy. First, engaging in judicial diplomacy. Second, supporting the development of a transnational system of justice. By judicial diplomacy, I refer to formal and informal communication and collaboration between courts in different jurisdictions. Informal cooperation between judiciaries has become relatively widespread in recent years, with the Conference of Chief Justices of Asia and the Pacific, the Judicial Seminar on Commercial Litigation, and the Judicial Roundtable on Commercial Law being just a few examples of such meetings that my colleagues and I, and indeed colleagues from the Supreme Court of India, actively participate in. These gatherings allow us to pool our collective experience in order to help us address the legal issues that are proving to be prevalent across jurisdictions. That is one of the reasons why I regard the invitation to address you today as so very special. Formal cooperation between judiciaries, once practically unheard of, has also gained traction. The Supreme Court of Singapore, for instance, has entered into memoranda of understanding with a number of foreign courts in order to allow each court to refer questions of foreign law to its counterpart in the foreign jurisdiction, greatly simplifying the task of ascertaining a complicated point of foreign law. We also help develop and have adopted the Judicial Insolvency Network guidelines to enable court-to-court communications for the management of complex cross-border insolvency cases, which is an extremely important case management tool in these cases. Perhaps the high watermark of international judicial exchange is the modern-day phenomenon of traveling judges. These are jurists who travel from their home jurisdiction to serve on a court in a different jurisdiction. Courts that have traveling judges in their ranks, such as my court, the Singapore International Commercial Court, are able in this way to assemble a particularly deep bench of eminent jurists from around the world and to benefit from their deep experience and the exchanges that this affords us. One of your erstwhile colleagues, Justice Arjun Sikri, now graces our bench as an international judge, and he makes an extremely valuable contribution to the court that goes well beyond the work of hearing cases. But reaching further than an international network of judges and courts, I suggest we should work towards an even more ambitious goal: the proactive development of the transnational system of justice. On a number of recent occasions, I've argued in favor of recognizing the existence of the system and working to develop it further in the area of commercial law. And I've suggested that we can see this by viewing the many discrete players and processes that regulate transnational commerce today as though they were part of a system rather than as a mere compilation of rules. In practice, we achieve this by promoting the convergence of substantive and procedural laws wherever possible. And this will have the undoubted benefit of reducing the uncertainty and costs involved in transnational commercial activity. Within a transnational system of justice, courts around the world can work in dialogue with each other as we develop and promote the legal norms that we will need in order to address the perfect long storm, including norms in areas such as climate change, jurisdictional conflicts, and natural justice. This would help us to strengthen the international rule of law, thus helping to facilitate and sustain the open flow of goods and services across borders and enhancing the ability of institutions around the world to respond to the global challenges that we face. The irreversible effects of globalization have made us all participants on the transnational plane, and judiciaries therefore should not underestimate the importance of the transnational element of their work. Instead, we should refine our vision of the judicial role to encompass international engagement, and this would make us more effective and at the same time promote public trust. Chief Justice, ladies and gentlemen, I offer these three themes as a base for developing a blueprint for how judiciaries can shore up their competence and legitimacy in the face of the perfect storm that is looming. First, redoubling our efforts to build a user-centric court system by recognizing that courts have an assistive responsibility towards court users and by engaging in public communications and outreach. Second, working tirelessly to enhance judicial competencies by investing in judicial education and training and pursuing continuous innovation in the justice system. And third, actively promoting international judicial engagement by engaging in judicial diplomacy with our counterparts across the world and contributing towards the development of a transnational system of justice. Finally, we should see that cutting across this revitalized vision of the judicial role is a need for strong leadership. To develop the kind of systemic approach that is called for, we need judicial leaders to develop an overarching vision and set the tone. And this should not be seen as the exclusive preserve of the heads of judiciaries. Judges and indeed court administrators at all levels need to be leaders within their own domains in order to drive and sustain change at the scale. At the start of my address, I painted a rather bleak picture of the perfect long storm approaching judiciaries around the world. We face global changes, the complexification of disputes, the challenges arising from greater interconnectedness amongst jurisdictions, rising barriers against access to justice, truth decay inside and outside the courtroom, and an impending breakdown of trust in public institutions. Meeting these challenges will require a multipolar effort. And while the courts cannot lead the charge against their root causes by refining our understanding of our role as judges, we can tap upon the strength and expertise of judicial institutions and redirect them towards responses to these challenges that accord with the constitutional role of the judiciary. We should aim to become institutions that excel in the administration of justice in the ways I have suggested. This is a critical mission. If we fail, the perfect long storm portends a breakdown of the rule of law. But if judiciaries are successful in this endeavor, they will help guide their societies through the tempest. I thank you very much for your attention.